Good morning and welcome to the DC Court of Appeals. As a general reminder, we ask that you mute your cell phones or put them in silent mode at this time so as not to disturb this morning's arguments. Thank you. All rise. All persons having business before the honorable associate judges, now presiding over the district of the Court of Appeals, draw near and give their attention. God save the United States and this honorable court. This honorable court is now in session. Please be seated and come forward.
Good morning, everyone, and welcome to the historic courthouse. We have two cases on the docket this morning. We will call the first case Carrington versus United States, 22 CM 580. Is everyone ready? All right, appellant's counsel.
Morning. May it please the court, Fleming Terrell on behalf of appellant Brittany Carrington. I'd like to reserve 2 minutes of my time for rebuttal. The evidence presented at trial that Marilyn Jones was hit with an umbrella when she physically intervened, trying to take it away from the person who was swinging that umbrella at her car windshield, was insufficient to prove beyond a reasonable doubt that those hits from the umbrella were intentional as opposed to inadvertent, as is required to sustain Ms. Carrington's conviction for simple assault and for possession of the umbrella as a prohibited weapon, PPWB.
Well, let's get clear on what the testimony was. So Ms. Brown testified in a couple of sentences that the defendant begins to use the weapon on my spouse in one sentence, and then another, she said, she proceeded to hit her with the object, the umbrella.
Right.
And your brief suggests that it's possible that the hitting with the umbrella occurred while the defendant was attempting to get Ms. Jones off of her when she was hitting at the windshield with the umbrella and Ms. Jones comes over and tries to get her to stop. The brief suggests that Ms. Jones was hit with the umbrella as Ms. Carrington tried to wrangle out of whatever hold Ms. Jones had on her or tried to stop her from taking the umbrella away or whatever. But that doesn't seem to be what the eyewitness, Ms. Brown, testified. Her testimony was she, Ms. Carrington, proceeded to hit Ms. Jones with the object, and she began to use it as a weapon. I mean, that sounds like testimony from which someone could infer intent to strike.
I think
your response to that.
yes, in isolation, and the government has pulled those few words out of the transcript and presented them in isolation, it could have that connotation. But this court should review it in the context of all of Ms. Brown's testimony about the circumstances surrounding those hits, and also Ms. Jones' testimony about the circumstances surrounding those hits.
Why is that required under a sufficiency standard?
Well, in reviewing the sufficiency, this court has said that it looks to, let's see, in Bynum, it has reviewed sufficiency of the evidence taken as a whole, rather than each fact individually. And here you have a credibility assessment by the trial court that both Ms. Jones and Ms. Brown were credible witnesses. And so this court isn't in the business as an appellate court of review in revisiting those kind of credibility assessments.
No,
So-
but I mean, and we're doing de novo review, but we're also viewing the evidence in the light most favorable to the verdict and drawing all reasonable inferences in the light most favorable to the verdict. So why was the trial court not permitted to credit simply Ms. Brown's testimony?
The trial court was permitted to credit simply Ms. Brown's testimony, but it didn't. It said that Ms. Jones was a credible witness as well.
Well, it could have found Ms. Jones also credible, but it could have found for that factual purpose that it was relying on Ms. Brown's testimony.
Arguably, it could have. I'm going to say in a minute why I think that even on its own, Ms. Brown's testimony didn't imply her view that it was intentional hitting, nor that that view is accurate. But also, the court, I think the government has agreed that the court did not make a finding about intentionality in this case. And so the court did not resolve any dispute between those two portions of the testimony.
Well, counsel, let me take you into a piece of the legal minutia on that. What exactly is the type of intent? Like, what intent did the court need to find to make this sufficient in your view?
In a completed battery case like this, and I want to be sure to get back to your question, Judge Thompson, about what was being said, because I think that's really important, but to lay the sort of groundwork on what the law requires. In a completed battery case like this, this court's binding precedent is clear that what's required is an intent not only to do the swinging, but to actually make contact, a purpose to make the contact. And we get that from a series of cases. The two most sort of directly factually on point are Buchanan and Williams. Those are the cases where an arrestee was throwing elbows, flailing, trying to avoid getting handcuffed. And this court said it's not enough to find that he intentionally was moving in that way. There has to be a finding of intent that he intended to inflict injury on the arresting officer, that's in fact the essence of an attempted battery assault. Likewise, in Williams, that was the case where an arrestee threw a shoe and it hit the arresting officer in the face. The arresting officer testified that it did not appear to be an accident, and this court nonetheless remanded because the trial court had made no finding as between that officer's testimony that it was not accidental and another officer's testimony that it
So
was.
could the proximity, the difference in those cases change it here? You know, that shoe was thrown at a distance, and we said in that case that it could have been aimed at the ground, it could have been aimed at the wall, the hit could be accidental. In Buchanan, they were flailing arms. In this case, there was an object. Having that object, could that change it in your view that has a likelihood if I am flailing around to hit somebody, and I should know that by nature of possessing it in that moment?
I think there's no, it doesn't change it. I think there's no more likelihood that the object will hit somebody than likelihood that the arms that the defendant in Buchanan was flailing around would hit somebody. And I mean, in that case, it was described as like a wrestling match with the arresting officers. It was a certainty that he was going to hit them. The question was whether he intended to cause injury. Just to finish up on the law, more recently in Perez-Hernandez, this court said in a case like this, citing Buchanan, so the shoe throwing case, said in a case like this, making contact with the victim, the touching portion of the offensive touching cannot be inadvertent, but rather must be the defendant's conscious object. And it was using the definition, the model penal code definition of purposeful. So that's the degree of intent that's required.
So
In
let
a-
me ask
in a
you
case
another
like this.
question along those lines too. If it was Ms. Carrington's intent to damage the car windshield and someone trying to defend that, they accidentally got hit, could we transfer the intent from the car windshield to the individual that was hit?
No, there has to be an intent to inflict injury or to make contact with a person and inflict injury on that person. And as to the facts on that question, even just looking at Ms. Brown's testimony alone, she used the words, the umbrella was used, or she began to use the weapon on my spouse, was part of an initial sort of rambling 3-page narrative that left out significant facts, left out that what happened between the umbrella hitting the windshield and her spouse being hit was that her spouse physically intervened trying to stop the umbrella being hit. And it's not just Ms. Jones that testified about that additional fact. When Ms. Brown was later walked through by the prosecutor in more detail, what it is that she said she saw, she gave a more detailed description, somewhat more detailed description. And she said that Ms. Jones attempted to stop the person from hitting the windshield after she had already been hitting it. And then she proceeded to hit her with the object. Now, in that sentence, proceeded to doesn't necessarily imply intent. It just puts a sequence of events in order. So we might say that the driver was rear-ended at a stoplight and proceeded to collide with the car in front of her. It doesn't necessarily imply intent.
Doesn't seem like the most natural reading of it, what you're suggesting. Your brief suggested that an example of someone who was walking on the ice and then proceeded to fall. And I will grant you that a natural reading of that is that's just the next thing that happened.
Right.
The ice was slippery, but here, it's not the way I read her testimony.
So we
Yes, she went over and tried to stop her from using the umbrella. She proceeded to use the umbrella to hit my spouse. They seem like separate.
So I think we do have to look at the
Actions.
context in which that statement is being made, or the context, the factual context that's being described, like the falling on the ice. And here, just to be clear, this is not a case like in Williams where the witness explicitly says this was no accident, right? This was intentional. So we're having to parse what it was that she meant. And the very circumstances that she describes, that those hits from the umbrella came after Ms. Jones physically intervened trying to stop the swinging at the windshield, create ambiguity about, make it harder to draw the inference that she meant by proceeded to hit, to convey that she believed that that was an intentional hit.
Do you have
And
a
then-
reading of the facts, one way or the other, on whether Miss Jones was hit or Miss Carrington hit Miss Jones, depending on how you want to phrase it, when she was standing and trying to stop the hitting of the windshield, or when she was on the ground? Because the testimony is unclear to me on that.
There's no substantive evidence in the record that she was hit while she was on the ground. The government has cited a colloquy with defense counsel that was an impeachment with what she had told officers on the scene. She didn't adopt that account that she had given on the scene as true for purposes of
I
the
think she
trial.
said something like, yes, that's right, or something like that, but.
Well, the colloquy was, let's see if I can.
Well, actually, let me stop you though for a second. Not to, you can still answer the question, but I mean, do you think it makes a difference if she was hit while she was on the ground?
No, so I think if you read that colloquy, you'll see that the questions were about whether she, what she had told the officers. And then there's one question sort of in the middle of that from defense counsel, just sort of like summarizing what she had said so far. It's not the type of question you would see with an adoption of, and did you say that because it was true, right? Even if that evidence, even if that colloquy were taken for the truth, it wouldn't matter. Because all it says is that she was fighting on the ground and hit in the back of the head. It doesn't say how many times. It doesn't say how she got on the ground. It doesn't say that the person with the umbrella was on the ground with her. Certainly not that the person with the umbrella was above her, repeatedly striking her in the back of the head, as the government has sort of posited in its brief. The record is just silent as to how the physicality of the interaction, as to whether the person with the umbrella was swinging it at Ms. Jones at all. There's no evidence that she was. As to where on Ms. Jones' body she hit her, how hard she was hit, how the two were arranged relative to one another. And of course, there's no testimony, unlike in the Williams case, that either witness explicitly perceived this as intentional. So going back to what I think is the government's best evidence in support of an inference of intent, these few words from Ms. Brown, we posit that proceeded to is already ambiguous, that the circumstances in which it is undisputed these hits occurred heightened the ambiguity of her words. And then Ms. Jones' testimony that she merely ended up being hit a few times, which does not ascribe volition to the person holding the umbrella, increases the ambiguity even more. So our position is that it is too much to draw from that the conclusion that Ms. Brown was trying to convey, that she perceived those blows to be intentional. But even if we do draw that conclusion, there is an additional inference that is just not supported by the evidence here, which is that she was correct in that view. What the trial court had to find was beyond a reasonable doubt that Ms. Carrington intentionally hit Ms. Jones. Not that Ms. Brown thought so, but that it was in fact the case. And there was no testimony from Ms. Brown or from Ms. Jones about the manner in which the umbrella came into
Wait, let me
contact.
see if I
with her.
understand that. I mean, the trial court credited Ms. Brown's testimony. Yes, Ms. Brown thought so. And the trial court credited the testimony. She credited what she described, her perception of what she saw. Was that not
Yes,
enough?
but without any finding, again, that what she was describing was viewing an intentional hit. And also
Well, I
credited.
mean, the question before us is whether the evidence permitted that inference, permits that inference. That's the question. Does the evidence that was presented permit that inference?
Our
It
position.
seems to me from the testimony of Ms. Brown, the answer is yes. Was there some ambiguity in the transcript? There was. There almost always is, right? It's in crediting the witnesses in part, what the trial judge has to do is to resolve the ambiguity, right?
Our position is that neither Ms. Brown's testimony standing alone, given the facts that she described surrounding those hits and the lack of any information about why she might have perceived them to be intentional, and certainly in combination with Ms. Jones's testimony, doesn't permit an inference that those blows were intentional. If the court disagrees, it would need to remand to the trial court to make findings on that question, as in Williams, as in Buchanan.
Well,
because the-
why is that the case? I mean, I know we have a second issue here that we need to get to, but why, I mean, in a bench trial, where's the requirement? We presume that trial courts know the law and apply the law correctly. And if they're finding that the elements of a statute have been satisfied, which they are necessarily doing if they're finding the person guilty, where's the requirement that they set forth their findings explicitly?
The requirement for the remand here comes from Carroll, which is a 2017 en banc case. It's one of many, and it collects other cases where when it is a bench trial rather than a jury trial, sufficiency is reviewed, drawing inferences, at least on questions for which the judge hasn't made findings in favor of the government. But once that sufficiency review is complete, if the evidence is deemed to be sufficient, the court has said that where the trial court had sufficient evidence but did not make the necessary findings on an element of the offense, it will remand to the trial court for the trial court to assess. That's different from a jury trial. And the court explained that that's because in a jury trial, or rather in a bench trial, we know whether the fact finder made or did not make findings on an essential element.
Well, you know, the facts of Carroll were so different. It was a threats case. And the court said for there to be a threat that's punishable by law, you either, the speaker must have intended the words as a threat or must have known they would be taken as a threat. And that's the kind of thing that it's difficult to tell from just hearing words. A finding has to be made. I mean, this is different. If I take a bat and I go after Judge Howard, whack, I think you can infer I intended to use force and violence on him. I mean, it's
If that is what the evidence had shown below, then I think you could.
well, there's
infer that.
Ms. Brown's testimony. She proceeded to hit my spouse with the weapon.
Which is an equipoise at best with the testimony from Ms. Jones that she merely ended up being hit. I think
Well, Ms. Jones was the victim, and it sounds like she wasn't too sure of what was happening. She didn't know who hit her. And that's understandable. But Ms. Brown was standing somewhat at a distance. She was trying to recount to the police what was happening. So she was watching.
well, these are exactly the kind of questions that this court sitting as a court of appeals should not be making on the cold transcript. I think that actually Ms. Jones said she couldn't say who hit her, but didn't say she didn't know what happened. Didn't say she didn't know how she was hit,
But you
right?
have-
And
You could have work. You could have even worse than equipoise, right? I mean, you're saying there's equipoise. You could have even worse than equipoise. You could have contradictory testimony. And trial court or finder of fact is still entitled to credit one over the other. So how does equipoise
It is, but
support your position?
well, the trial court, it's the trial court that's entitled to draw those credibility assessments. And here the court generally credited both accounts. We think that's because they are consistent about the sequence of events that happened, and neither one of them implies an intentional hitting.
But we also have a standard of review layered on top of that. That means we're supposed to draw reasonable inferences in favor of the verdict.
Yes. So our position is that on this record, it is not possible to draw a reasonable, non-speculative inference that not only did Ms. Brown mean to say, without saying in so many words, that these blows appeared to be intentional, but that perception was accurate, where we have no description of how those blows happen. You know, as we've said in our brief, there's any number of ways in sort of a tussle over the umbrella that they could have occurred. And if the court disagrees, a remand would be necessary.
Speaking of inaccurate perceptions, may I draw you to the umbrella now?
Yes, thank you. I wanted to be sure to get to that because in addition to the mens rea insufficiency, the evidence here is also insufficient to support the PPWB conviction because it was insufficient to show that the umbrella was used in a manner that was likely to inflict the kind of horrific wounds that this court has defined under the aggravated assault statute and also under the PPWB statute as a serious bodily injury. And in order to prove the weapons element of PPWB, that the umbrella was a dangerous weapon, the government agrees with us that the trial court had to find that the umbrella was used in a manner that made it not just able, but likely to produce death or that kind of serious bodily injury. Those are injuries that involve a substantial risk of death, unconsciousness, extreme physical pain, protracted obvious disfigurement, protracted loss or impairment of a function of a bodily member, organ, or mental facility. It's not a cut, it's not a bruise, it's not even a significant bodily injury that requires hospitalization or immediate treatment.
So can I get you to parse out a little bit the difference between the object here and the manner in which it was used? So let's say, and I know you're not conceding this, but let's say Miss Jones was hit while she was on the ground to her head when she was in a vulnerable position by this umbrella. Would it satisfy the statute?
No.
At that point? Based purely on the nature of the object itself?
Based purely on the nature of the object itself and what this court has previously described as the best evidence of the dangerousness of a weapon, which is the injury that it actually inflicted. There's no evidence here that any blows to the back of the head with the umbrella, if there were any, caused any injury whatsoever, much less the kind of serious bodily injury.
Our definition of a dangerous weapon, though, uses this language approximately. I may not have it exactly, but it is known to be likely
Yes.
to cause serious bodily injury. So we've never actually said that the object had to cause serious bodily
That's-
injury, have we?
No, no. And in fact, this court has said it doesn't have to actually cause that kind of injury, but it has also said what injury it does cause, where it is actually used on the person, is the best evidence of whether it is likely to cause. that
It's
kind of
certainly
injury.
some evidence. But you know, we don't know. I agree with you that there's some ambiguity in the transcripts. And so it's not clear to me whether Ms. Jones was hit while she was on the ground, hit with the umbrella while on the ground, or hit while she was standing up. It's not clear. There is an obvious red space on her face close to the eye. So that seems to be of some relevance that if the umbrella did that, we don't know that it did.
We don't know that
by
it
the
did.
way, but if it did, it was awfully close to the eye.
So it would have been the government's burden to prove that the umbrella did that.
Let me ask you this question too. Your client was convicted of attempted possession of a prohibited weapon. What are the elements of that? I mean, we've said about attempted possession of a controlled substance, let's say cocaine. You can be convicted of attempted possession of a controlled substance, cocaine. If you thought it was cocaine,
Mhm.
even though it wasn't. It was, I don't know, baking powder.
Well, I'll,
Does the object for attempted possession of a prohibited weapon have to be a prohibited weapon? Or do you just have to think it was? And I realize that that raises a question of intent too.
Right.
What did Ms. Carrington think? But do you know the answer to that question?
this is a bit of a kettle of fish. It hasn't, I don't think the court needs to get into it because the government didn't argue below, hasn't argued here an attempt theory. As an attempted charge for a bench trial. But the theory below was not that she attempted to possess a prohibited weapon. It was that she did in fact possess a prohibited weapon. That wasn't the basis of the trial court's conclusion, trial court's findings below. So this court, again, will not affirm convictions based on a theory that wasn't either presented to a jury or relied on by the trial court. So I don't think the court needs to go there. If it did, if we were going to draw an analogy to the drug cases, I think you would, maybe in a case where the person thought what they were picking up was in fact a baseball bat and they were wrong about that, or they pick up a water gun that looks real, they thought it was a real gun, perhaps there would be more argument that would suffice, but there's no evidence that's what was happening here.
Well, counsel, let me ask you what you make of our Stroman case. There, we said in a prosecution for attempted possession of a prohibited weapon, the government has to prove beyond a reasonable doubt that the defendant possessed the weapon with the specific intent to use it unlawfully. And we went on to say to prove attempt, the government must show the intent to commit a crime and the doing of some act towards its commission that goes beyond mere preparation. I'm not sure that makes it that much clearer for me, but I'm interested in your take.
I think the sum act would have to be like attempting to take possession of something that is in fact one of the enumerated weapons, or at a minimum, possessing something within the mistaken belief that it was such a weapon. There's no evidence here that Ms. Carrington believed the object to be anything other than an umbrella, an ordinary umbrella. That's, the government, the trial court took on its face her testimony that she removed the umbrella from the car. So that's just not in play here, even if it were a permissible basis for this court to be considering an affirmance.
Let me ask you a very factual question. The photo exhibit that we have in the record cuts off the top of the umbrella. Does this umbrella have a tip on it or not? You did. You only have
The umbrella was not introduced into evidence. The court never had an opportunity to examine
So
it.
it was just that photo that was
It was
introduced?
just those photos that were introduced into evidence. No evidence of its weight, its heft. For all we can tell, it's an ordinary umbrella, which is an object that is purpose-built to be lightweight. It's covered in fabric. And there's no, you would have to be using it in some very extreme sort of way.
So counsel, let me follow up there. Without making any sort of factual finding, it looks to me very much like a Costco golf umbrella I have, which I agree with you is very lightweight and fabric covered. And I wonder whether the tip is necessarily that relevant, because as I recall the record, it was that rubberized handle that is very much in the picture was what was being swung, correct?
There is some testimony from Ms. I believe it's from Ms. Brown, who was asked in detail to describe how it was being swung at the windshield. That makes it sound like it might have been that handle and that was hitting the windshield. Whether that's what hit Ms. Jones, there's absolutely no evidence in the record.
Well, let me follow up on that then as well. Would you tend to agree that as we look at the specific record and we're thinking about that element beyond of known to be likely to produce death or great bodily harm, that if the umbrella could smash a windshield, it could probably smash a head or a body part?
Again, first, there's no evidence in the record about the degree of force that was required to cause the cracks to this windshield. The windshield was not shattered out. I think there are pictures in the appendix of what the windshield looked like. There's no evidence about the degree of force that would be required to cause that. We know, a pebble kicked up from the road can cause pretty significant cracks to a windshield. So it's not clear that it takes that much force, particularly after the car had been involved in a front-end collision. And even if we can infer that a great deal of
involved in a front-end collision.
I believe it was
a
the front end.
sideswipe?
I believe it was, well, I think the way the collision happened, it was the front of the Jeep that sustained some damage. In any event, it had been involved in a collision. And there is also absolutely no evidence in the record that the umbrella was used to hit Ms. Jones with the same degree of force or in the same manner that it was used to hit the windshield. I mean, it's sort of a
I mean,
glaring
does that have to
exception.
be in the record? Because it's not that it was a deadly weapon in the moment, but known to be capable of, if I had to paraphrase down our longer sentence.
Well, I don't know that hitting no, so the use at that point, if we're talking about what we would know could be inflicted from the force that was being used to hit the windshield, the use for that was to hit the windshield. That's not capable of inflicting injury on any person. So we would need to know how it was being used to hit the person. And as we've said, for all we can tell from this record, it was, bumping against Ms. Jones in a struggle over the umbrella after Ms. Jones physically intervened. Even if this court were to conclude that it was being used intentionally to hit her in some way, which I think is not a conclusion that the record supports or that this court should be drawing. There's no evidence that being hit with an umbrella, this is not a poking or stabbing kind of situation. There's absolutely no evidence, and the government has never argued that it was used in that manner where the tip of the umbrella would matter. There's no evidence that it was used near the face. The back of the head is the closest that the record comes, and that again is an impeachment testimony. And so because the umbrella itself is not the kind of object that is obviously capable of inflicting these kind of really serious, grave wounds, there has to be something. The government has to prove something about the way that it was used to show that it was not only possible, but likely to cause those kinds of very, very serious injuries. There were no such very serious injuries. And so for that reason, we think that the evidence was also insufficient to prove the weapons element of PPWB.
Thank you, counsel. We've got your 2 minutes reserved.
Thank you.
All right. Counsel for the government.
Thank you, Your Honor. Your Honors, may it please the court, Nicholas Miranda on behalf of the United States. Your Honors, the case is before the court on sufficiency of the evidence review. As both you, Judge Shanker, and you, Judge Thompson, have referenced, under this standard, the government need not dispel every alternative reading of the facts supplied by opposing counsel. Rather, the court is required to view the record in the light most favorable to the government, make all reasonable inferences in favor of the government, and affirm so long as there is any evidence produced upon which a reasonable mind could fairly conclude guilt beyond a reasonable doubt. I'd first like to turn to the evidence as relates to simple assault. One important piece of evidence that was discussed in opposing counsel's argument here is the exchange regarding where she says that she was hit in the back or in the back of the head. That is the exchange that begins on page 103 of the August 1st, 2022 transcript at line 15. The exchange that opposing counsel states is hearsay. Because it's so fact specific, I would just like to read this exchange briefly. Begins at line 15 with question. And you told the officers that you were hit in the back of the head because you were on the ground fighting when you were struck by the umbrella, correct? Answer, correct. And then there's a second question and answer. Question, okay, so you were being struck in the back, so you couldn't see who was swinging the umbrella, correct? Answer, correct. This second question and answer is properly admitted as substantive evidence and not hearsay. In the second question and answer, the defense counsel is asking her under oath about whether it is true that she cannot identify who hit her because she was being struck in the back of the ground, being struck in the back while she was on the ground. She accepts the premise, the truth of the question, and adopts it, saying that that is correct. She cannot. In addition to this evidence and these statements of Ms. Brown, as mentioned by Judge Thompson, there's also the circumstantial evidence of the intentionality for the assault.
Okay, but Ms. Jones also, and I understand your point that there's some evidence that she was struck while she was on the ground, but the very same witness, not a different witness, the very same witness also said that she was struck when she was, I mean, I don't know, but presumably when she was standing and trying to pull Miss Carrington away from hitting her windshield. So how did, it doesn't look like the trial court ever, dealt with that inconsistency.
The trial court did not, and I don't believe that those statements are necessarily inconsistent, Your Honor, because she testified that she was struck multiple times. She says at least 3 to 4 times. So one possible factual scenario, and certainly drawing inferences and viewing the record in the light most favorable to the government, that would be permissible, is that she saw the windshield being struck. She goes to intervene to stop further damage to her then fiance, now wife's windshield. The defendant then turns the umbrella on her, starts striking her. She falls during the struggle so that she's now on the ground, and then she is struck again while she's on the ground. That is an entirely consistent interpretation that marries both of those statements.
She didn't actually say that though, correct? She didn't say I fell onto the ground while being struck with the umbrella. Did she? Because she describes this general brawl of all the people who were involved. And then she gets a question about the brawl eventually came to an end, correct? Yes, the brawl ended. And I'm not sure what the next question was, but it was something to the effect of, and then what happened? Well, the next thing that happened is I saw the person with the umbrella going at my windshield, so I went to try to stop her. I don't think she ever testified that she fell during that part of it, did she?
Well,
I
Your
mean,
Honor,
there are these answers she gave to the questions you read.
Yes, Your Honor, and I just want to be clear, Your Honor, that there are 2 different scenarios, or 2 different kind of, whether you want to call them assaults or fights or however we're describing them, there are 2 separate engagements. It's, I guess, perhaps the most neutral way to phrase it. There's the first one where everybody is consistent that there was no umbrella involved at all. And then there is the conclusion, people characterize it differently. It died down, the brawl stopped. And then after the conclusion, it is uncontroverted that at that point, Miss Carrington goes to her car, is either sitting in her car or goes to her car for the purpose of, but regardless, comes out and brings the umbrella out at that point. She testifies that's when the umbrella comes into play, as in after the first and before the second. And then we do have testimony regarding the shattering of the windshield with the umbrella, and then the assault, as we would characterize it, of course, but the hitting of Miss Jones by Miss Carrington. And it is in reference to that this question and answer on page 103 takes place. So a reasonable interpretation is, as I just referenced, that in fact, there was a struggle. She was hit with it, with the umbrella, after she tried to stop her from hitting the windshield, that there was a struggle, that during that struggle, she fell. And again, referencing the question, she says, so you were being, the second question and answer, so you were being struck in the back, so you couldn't see who was swinging the umbrella, correct? And the interpretation to understand that question and answer, one can infer that that question and answer is in fact read in context and in reference to the prior question. That is to say that in the first question and answer, the defense attorney is saying, well, you told the officers on this night that you were on the ground and you were hit in the back of the head, so you couldn't identify the defendant.
So
And
counsel, if I can interrupt you there, I don't necessarily disagree with the line you're going down. Your opposing counsel said, so what, essentially? It doesn't matter whether she's on the ground or not. I get the idea where being on the ground maybe matters to say, you know, if this was a scenario where there's like a sucker swing or something, but presumably from all the evidence in Ms. Jones' own testimony, she was trying to wrestle this umbrella away and defend the car. By the time she was on the ground, she was presumably knowing that she's fighting and she's probably defending herself, or should at least be expected to try to cover her head or something. What is it, a difference without a distinction that she's on the ground versus standing and having an umbrella swung at her?
No, Your Honor, I think it is a difference with a distinction, both as to simple assault and attempt PPWB. As to simple assault, to the extent that opposing counsel is now presenting this on appeal for the first time, this accidental swing theory, it entirely goes against that theory. Because the theory of the accident has to be that she was standing in between the car and the defendant and accidentally got struck with the blows. But if she is on the ground while she's struck, she couldn't possibly be literally in the line of fire, so to speak, between the defendant and the car. So that substantially cuts in favor of, certainly with all reasonable inferences drawn in favor of the government, in favor of it being an intentional rather than accidental strike. So that's as to the simple assault, and it is powerful evidence as to the intentionality to the extent that that is in question for the simple assault. As to the attempt PPWB, first, Your Honor, I would just like to back up for a second with regard to the characteristics of the umbrella. I believe that Your Honor is correct. Again, while not entering it into evidence, the pictures themselves aren't evidence. And Your Honors can view the pictures, and it does appear from the pictures that it is a standard large golf umbrella. I believe it is from the pictures a totes brand, standard large rainbow golf.
Take it, you don't know if it came from Costco or not.
I don't know if it came from Costco. I got
Maybe a
mine,
sports store.
but Your Honor, so the characteristics of the umbrella being that, and immediately prior, knowing that it was used with such force so as to break the windshield, and Your Honors can see the damage to the windshield. It is substantial damage. It's not just in one point, but in multiple points. And as the officer described it, spider webs cracking throughout. The fact that that was done immediately prior, and now the victim is on the ground, unable to defend herself, literally not because, and being struck in the back or the back of the head, that positioning itself further evidences the likelihood of it possibly causing significant.
Well, let
bodily-
me ask you there, counsel, the pictures we've got, which I've got a printout of here in front of me, show the handle broken off. These umbrellas are lightweight. Most umbrellas are to be useful and able to carry around. This record looks murky. If this thing smashed the windshield, how do we know, or how can we reasonably draw an inference that that wasn't when the handle broke off? And if it was being swung in the same way, what someone was hit with wasn't the fabric with a few plastic nodes pointing out, that wouldn't have been nearly as likely to cause damage as the rubberized, heavier handle piece.
Your Honor, you're correct, Your Honor, that there is no evidence as to when the handle broke off. However, Your Honor, even again, this is a situation where the inferences and there is a reason why I continue to go back to the standard of review. And this is the opportunity where the inferences really, again, come into play. However, even if the court were not to draw that inference, even if it were just the long fabric covered portion of it, the fact that she was struck in the back or the back of the head while on the ground itself could carry a substantial risk of unconsciousness. And this point as to specifically where on the body seems to be a core point for this court in determining this. For example, in Johnson versus United States, a 2019 case for this court, there was testimony in that case that the defendant was striking her 13-year-old son with a stick. And while across his body while he was sitting on the ground, that in that case, as in this case, it caused only bruising. But the court specifically noted in finding that it was sufficient to establish attempt PPWB that, quote, she did so, quote, indiscriminately without taking any precaution to avoid striking parts of his body that would cause serious injury, such as his head or face.
But so do you think that I'm going to set out a factual scenario that seemed to be consistent with what you were just saying. So Miss Jones is on the ground. She's being hit in the back of the head, but it's with the fabric part of the umbrella. And I'm not saying you know that, but that seems to be what you were just setting out as a hypothetical, that could cause serious bodily injury.
It could, but we don't have to reach that conclusion because the record is ambiguous. The inference as to being struck with the umbrella generally is there rather than just the specific part of the umbrella. Moreover, we also have evidence that just immediately prior, the defendant was using the umbrella as is described in the court testimony, was using the handle side, that is the rubberized or plastic side of the umbrella to strike. And it was demonstrated forcefully with two hands over, raising the hands over the head and striking in a downward motion. If she interceded at that point, as there is evidence to suggest, certainly the court can infer that that is the manner and nature in which the umbrella was used against her, especially given the close proximity. in
But
time.
there's, I mean, there's, I realize we can draw inferences, but there's zero evidence of anything like that, right? I mean, that would be requiring us to completely read into the record or speculate.
I'm sorry, Your Honor.
There's zero evidence that, I mean, it seems inconsistent with what you've already said. You said, I mean, you seem to be wanting Miss Jones on the ground. Now you're saying that maybe she was standing and was hit in the same manner that the windshield was hit, but there's just zero evidence of that. So even if we can draw inferences, we have to draw them from some base of evidence, and we don't have anything.
That's correct, Your Honor. And just to be clear, if I wasn't clear before, I apologize. I'm saying that it is consistent that she was struck in both locations. That is to say that she was trying to intercede. And so, again, drawing inferences and not losing our knowledge of kind of everyday movements, if she is trying to intercede and stop someone from striking her car, the first strikes, as she testified, could very well have happened while she was standing and trying to intercede. And then during that struggle, she falls to the ground. So again, and then she does testify that she struck while on the ground in the back of the head. So these two are consistent rather than inconsistent. But the first.
I think you're right that the evidence permits a number of inferences. I just wonder if we're building on them too much. For example, you might say that the evidence related to the assault permitted the court to infer, let's say that that the victim was struck intentionally while standing and after she had tried to stop the defendant from smashing the windshield. That's an inference the court might draw. Or maybe the court might draw the inference from the testimony you've been emphasizing that the strikes with the umbrella happened while the victim was on the ground. But if we don't know which inference the court drew, can we rely on the availability of the inference to get what we would need to sustain the attempted PPW conviction? In other words, if we need to conclude something about the manner in which the umbrella was used, but we don't know which inference the trial court drew, is that a problem for us?
No, Your Honor, it's not a problem. We do know that the trial court credited the testimony of both Ms. Jones and Ms. Brown. So if there is evidence within that testimony that does support that, that is sufficient. And I just want to be clear, if I may, on what is required and not required of the trial court's findings. And as an initial matter, as Judge Shankar mentioned, the trial court is presumed to know the law and to be applying it. Unlike in the case referenced by opposing counsel, Carroll, in that case, there was evidence or there was argument, and certainly the court found it persuasive, that the trial court was misapplying the law, or rather was applying an incorrect standard. That evidence we don't have here. And moreover, under Superior Court Rule of Criminal Procedure 23C, the court is not required to make factual findings in a bench trial and not required to make any specific factual findings after a bench trial unless requested by either party. And there is certainly no evidence here that either party requested specific factual findings. Moreover, in the context of this case, it makes perfect sense as to why the judge didn't make factual findings as to this particular matter. And not only was he not required to and presumed to know the law, but this wasn't the core issue. If Your Honor, in reviewing the trial transcript, you will see that there were arguably two core issues. The primary issue was identity. And the secondary issue, such as it was self-defense. So in that context, it makes perfect sense as to why Judge Richter's trial court decision is framed in that manner and focused on those issues.
I think Ms. Terrell is probably correct that we don't need to go to this issue of the elements of attempted possession and whether the object had to be a prohibited weapon. But do you happen to know the answer to that question? Can you be convicted of attempted possession of a prohibited weapon if the item was not a prohibited weapon, but you thought it was, or you intended it to be?
I don't think that is the case here. There's any evidence that that's the case, and I would not want to speculate without knowing more.
It's probably a wise answer.
All right, if there's no further questions, thank you, counsel.
Thank you, Your Honor.
Ms. Terrell?
Thank you, Your Honors. Just a few points. First, neither the prosecutor nor the trial court treated that answer on cross-examination that the government is relying on so heavily now as substantive evidence at trial. We think that's rightly so, because if you look at the colloquy, you'll see that it was not just preceded by questions about what Ms. Jones told police, but also followed by questions about what Ms. Jones told police. And in that context, it reads as if it's just a sort of verbal placeholder by the defense counsel. Okay, this is where we are, not an adoption of that statement to police. The prosecution didn't argue below, and the trial court didn't find below that Ms. Carrington beat Ms. Jones in the back of the head while she was on the ground based on that testimony or anything else. That's an entirely new theory here on appeal from the government. The trial court found to the contrary that Ms. Jones, that the umbrella hit Ms. Jones with the umbrella when Jones tried to restrain that person, not Ms. Jones approached her and the person turned around, knocked her to the ground and started beating her in the back of the head.
Do you still stand behind your argument before that it doesn't matter whether she was on the ground or not?
I was just about to get to that, Your Honor. Yes, even if we take that one question and answer from the transcript as adopted for the truth, Ms. Jones said only that she was on the ground and hit in the back of the head. She doesn't say anything, or I'm sorry, on the ground and hit in the back. She doesn't say she was hit in the head in that one question and answer. She doesn't say how she got on the ground. She doesn't say where the person holding the umbrella is, whether she's also on the ground. The government has said here in its oral argument that that scenario, the only way that the blows here could have been inadvertent is if the blow aimed for the car landed on Ms. Jones instead, if she threw herself in the way or something, but that's simply not accurate. Ms. Jones may well have tackled the person to the ground, may have come up to her and tried to grab the umbrella and thrown her off balance. The two could have fallen to the ground together, and the umbrella could have bumped Ms. Jones in the back as they went down.
So your opposing counsel made a preservation argument too, saying that this idea of inadvertency is entirely new, and I don't know whether that's true or not. I recall in the record that I wasn't the one who swung the umbrella. Someone took it from me. Like where is this inadvertency at the trial court level?
Well, the trial intention, purpose is an element of the simple assault and of the PPWB. The weapon must be possessed with an intent to use it unlawfully against another. We've argued that means against another's person, and the government really hasn't disputed that statutory analysis. So that was an element that the government was required to prove of both of those offenses. And it is self-evident from the evidence that came in about the circumstances in which those hits occurred, and from Ms. Jones's characterization of those hits as non-volitional, basically. She ended up being hit. That there is a question about whether there is reason to doubt whether those hits were intentional, and the trial court was required to resolve those questions. Does it matter, as the court said in Carroll, it is a matter of due process that the fact finder find the elements of the offense beyond a reasonable doubt. And so there's not a preservation here. Carroll also says that it's well established that just the entry of a not guilty plea preserves all sufficiency challenges. Again, the nature of the injury has to be, talking about the dangerous weapon question now, the nature of the injury or the likely injury has to be way more than cuts, bruises, a sore back. There's no evidence of any kind of injury here, and none that the fabric end of the umbrella, which the testimony was that it was a long, skinny object that was hitting Miss Jones. So that's the fabric end, if it had already broken, and there's no evidence that that
Why?
was used.
Wouldn't it still be a long skinny object with the handle? I agree with you that the
Well-
evidence is ambiguous and murky here.
Sure. I guess it depends on how long you think that handle is in the picture, and there's no scale to tell.
But I'm saying if the handle was still attached.
Oh, if the handle was still attached, yes. Well, there's just no evidence as to whether it was that end or the other end. But whichever end it was, without any evidence that the umbrella had a particular heft, without any evidence that the umbrella was used for the kind of vicious beating that I think the government would like this court to speculate is what happened, there is simply not sufficient evidence to prove beyond a reasonable doubt that it was used in that manner. And likewise, on the question of intent, you know, this couple of words from Ms. Brown, again, is the best evidence. Perhaps if you want to think that the cross-examination question was an adoption, along with the fact that she was on the ground fighting at some point when she was hit. That might be some evidence, slight evidence, but Rivas says slight evidence is not enough. A mere modicum of evidence is not enough. In Wiley and in Harris, this court has looked at scenarios where the evidence was in equipoise or where there were multiple scenarios like the ones I've just described that were as plausible as possible as the one implying guilt. That is not enough. Rivas tells us even evidence that makes it more likely true than not that the blows were intentional is not sufficient. It has to be beyond a reasonable doubt. The trial court made no such finding here. The evidence is not sufficient to support such a finding. If this court disagrees with us on that, a remand is required. Carroll requires that because it says where it's been a bench trial and the trial court did not make the necessary findings, unless this court can conclude under a Chapman standard beyond a reasonable doubt that that didn't matter, that the court would have made the necessary findings, it will remand, and the court cannot draw that conclusion here. Also, it's not just Carroll. Buchanan and Williams are two more examples of cases where there was sufficient evidence of intentional assault, but because the trial court had not made a finding on whether the assault was intentional, this court didn't decide the question itself. It said the evidence is sufficient and remanded for additional findings. So at a minimum, we think a remand is necessary here on the mens rea questions, and that the PPWB conviction must be reversed in any event because the government's evidence was also insufficient to prove that the umbrella was used as a dangerous weapon.
Thank you, counsel. The case is submitted. All right, we will now call the second case on today's calendar, TOVAR v. REGAN, ZAMBRI, Long, PLLC et al. Case numbers 23 CV 165 and 23 CV 217. Prepared to proceed? Appellant's counsel.
Good morning. May it please the court. My name is Benjamin Ogletree, and I am privileged to represent the appellant cross appellee Roger Tovar in this appeal. Respectfully, if I could, I'd like to reserve 4 minutes for rebuttal.
Thank you, counsel.
This is a legal malpractice case in which the defendants, who are the appellees here, represented Mr. Tovar in an underlying lawsuit stemming from a 2012 severe automobile accident that left Mr. Tovar severely and permanently injured. In this lawsuit, in this case, Mr. Tovar alleged legal malpractice by the defendants based on their failure in the underlying matter to pursue a claim for Mr. Tovar's future medical treatment costs, which he will need for his ongoing medical care. In the trial court below, in this case, the defendants immediately filed a motion to dismiss under Rule 12b-6 for failure to state a claim and/or for summary judgment. Now, at the time, I want to point out to the panel that the defendants were seeking an early exit from the lawsuit. At that time, the defendants had not filed an answer. No depositions had been scheduled. There had been no initial scheduling conference. There was no scheduling order. Mr. Tovar himself had promptly served discovery requests on the defendants before the motion was filed, and that they did not, to which they did not respond until after the motion had been filed. And as we explained in our brief, unfortunately, in several respects, the responses that the defendants provided were incomplete and evasive with respect to particularly important issues that were raised in their motion. The defendant's motion, importantly, was supported by an affidavit from defendant Cornoni, who served as the lead trial counsel for Mr. Tovar in the underlying matter. Mr. Cornoni's affidavit was packed full of brand new factual assertions that were offered in support of unpled affirmative defenses that Mr. Tovar had heard was hearing for the first time. And in response, Mr. Tovar made a request for discovery, further discovery, prior to a ruling by the trial court on the summary judgment issue. In this order that is the subject of this appeal, which ironically was issued one day after the trial court had extended all of the discovery deadlines, the trial court specifically said that it granted only the defendant's Rule 12b-6 motion. And for that reason, it did not reach the summary judgment motion, although the trial court did say in passing that if it had addressed the summary judgment issue, if it had reached that question, it would have granted that motion too.
So counsel, let me ask you, is it your position that a trial court is necessarily barred in all cases from granting summary judgment while discovery is ongoing, or is it discretionary to some extent? And or I say discretionary, but more to the point, can a trial court determine that additional discovery would be futile or would not edify any of the facts that are central to the summary judgment decision? And if
So, Your Honor, I think the rules are clear that summary judgment can be moved forward anytime. But by the same token, particularly in the traveler's indemnity case that we cited in our papers, and the fact that my friend on the other side, they cited in theirs, that under Rule 56F, actually, I think it's now 56D, that the trial court has a duty to make sure that the record is complete, that both sides have had an opportunity to fully explore and discover their evidence and to put on their cases. And initially, well, futility perhaps, I guess in the abstract, may be a decision that a trial court can make as to why discovery isn't necessary. The trial court in this case never addressed Mr. Tovar's request for discovery at all. It's not mentioned in his order as to why it wasn't granted.
well, it does, but I guess the question then now is, to the extent the trial court ruled on a judgmental immunity basis, can you point to what discovery your client might have pointed to defeat that
Certainly.
ruling on summary judgment?
Your Honor, in the trial court below, Mr. Tovar, both in his Rule 56D affidavit, in his briefing, in his statement of materially disputed facts, and repeatedly before the trial court at oral argument on the motion, pointed to the following examples. In Mr. Cornoni's affidavit, one of the justifications he offered for how he reached his decision that not to pursue a claim for future medical care was a strategic decision, so he said, was he claimed that he had discussed this and consulted with various members of the District of Columbia Bar and sought their input and advice. He did not identify, even though Mr. Tovar had asked in the discovery that he had served prior to the motion, list all, he actually can quote it, he said, list all other persons other than experts who have discoverable information that tends to support the position you've taken or intend to take in this action. Well, by then, the names of those DC bar members with whom Mr. Cornoni claimed to have consulted were certainly relevant to that issue, because question would be raised, Mr. Cornoni, what did they say to you? What did you tell them? What advice did they provide? Who did you talk to? Those are certainly discoverable
I mean,
issues.
it seems like you could go down that route and trial court could certainly want to know that, but it doesn't necessarily need to know that. I mean, at some level, it seems like the argument could be made that Mr. Cornone's mere consultation with those people, and we assume that it's true because it was in an affidavit submitted in support of a summary judgment motion, would support a notion that he at least engaged in the reasonable due diligence, which would support a judgmental immunity claim. Regardless of what, sorry,
I didn't mean to-
regardless of what those people told him. I mean, they could have told him, do it, don't do it. But that's not what I mean, we don't require him to have made the correct decision. We just require him to have made a reasonable decision, presumably based on some due diligence, which this affidavit would support that he did, right?
Well, therein lies the question. Who did he actually speak with these other people in the bar? I don't know. The record doesn't say. And what did he, I don't think that consulting with someone in and of itself provides a basis for granting a judgmental immunity defense as a matter of law, because the question becomes, when you consulted with him, what did you tell them? Was it a true consultation? Or did you tell them just the facts that you wanted them to hear to reach your conclusion?
Well, counsel, help me with this under the laws. I look at that judgmental immunity claim. And if we're looking at this, and I would agree, it's more of a summary judgment context when we're looking at it. You know, cases like Strickland come to mind, which are not judgmental immunity, but that also talks about how we look at 20/20 hindsight on things. To what extent do we get to dig into all that versus we have established the attorney made a strategic decision, whether good or bad, and we don't now jump backwards?
So respectfully, Your Honor, whether the attorney made a strategic choice or it was a matter of neglect was a hotly disputed issue of fact. Mr. Tovar vehemently opposed just the presumption that was what happened. In fact, he did it in two ways. First of all, Mr. Tovar pointed out, and in my personal view, was the most powerful bit of evidence that he offered. Mr. Tovar pointed out that when the defendants made strategic choices about his case, they consulted with him. For example, the defendants made a strategic choice as part of the litigation strategy, not to pursue a claim for his past medical care damages. And when they did that, they brought it to his attention. They talked to him about it. They identified the pros and cons, and they sought his approval. So that certainly lends credence to the notion that that's their pattern and practice. That's what they do when they're making strategy choices. They involve the client. No such conversations. The record doesn't indicate any such conversations occurred with respect to the issue of foregoing future.
I wanted to ask you about that because it wasn't clear to me how the attorney's consultation with Mr. Tovar or not was relevant to whether the decision that got made was a reasonable one. But you're saying that it bears on sort of the first prong of that judgmental immunity point, whether they actually made a strategic decision, because in this case, Mr. Tovar would have presented evidence that they did what you just described, that they always consulted with him on
That is correct, Your Honor. Just to drive home that point, this was in Mr. Tovar's statement of disputed material facts. It's at the appendix at page 1157 and it's paragraph 10. Plaintiff disputes that defendant's omission of a claim for future care was a conscious decision, given and he identified, he said, given the inconsistent positions throughout the underlying matter, and he was citing other examples of pretrial filings in which the defendants had identified his need for future care as an important issue for trial, which he would point out was completely inconsistent with the argument that they were now making, that they decided to forego seeking those damages. Again, it creates an issue of fact. Did you make a decision? Was it a neglect or something else?
I don't see it as inconsistent. I mean, maybe you're right that it at least creates an issue of material fact, but I mean, it seems to cut both ways. That you could argue that if they never mentioned it at all, that points to the fact that they forgot about it. Whereas the fact that they had considered it at one point and then chosen not to do it suggests that it was a strategic decision. But I guess that's not really for us to decide.
Your Honor, your question speaks to exactly my point. The record doesn't say. We don't know what it is, but Mr. Tovar has certainly raised enough evidence to create a disputed issue of fact on both prongs of the judgmental immunity defense, which I want to say and point out because the trial court relied heavily on this court's case in Biomet, right? I'm sure you saw that. Biomet was very different. Biomet was a case that where the court formally adopted and recognized the judicial immunity. I mean, it had been acknowledged sort of somewhat in prior cases, but that's where this court really doubled down and embraced the judgmental immunity defense. And Biomet was very different because in there, the first prong of the first element of the judgmental immunity. I'm sorry, I keep saying it.
We will take
Was-
judicial immunity as well if we can.
It was stipulated, not stipulated, but there was no dispute. All the parties agreed in Biomet that the decision in that case, and I believe it had to do with a decision to forego appealing a punitive damages award to the federal circuit because that the parties all agreed that that was an exercise of professional judgment. The sole issue to be decided in Biomet was prong two, the reasonableness. And the reason why this court felt comfortable and it was a summary judgment case. The reason why the court felt comfortable taking that issue away from the jury was because it involved an unresolved question of law. In particular, the court made clear when the alleged malpractice involves an unresolved question of law, we're not going to say that the lawyer has to predict the future. He has a crystal ball to know what the law will be going forward. And so the court specifically treated cases involving unresolved issues of law or unsettled questions of law differently. There are no unsettled questions of law here. This case involved purely factual questions.
Well, speaking of unsettled things, if I could draw you to another area of the playing field here, what if we were to look at this under that 12B6 standard still and really focus on the pleading of proximate cause? What would your response be there?
My response would be that we properly pled it, that the trial court did not find otherwise, and that for purposes of proximate cause, Your Honor, this court has, we recited in our brief that where Mr. Tovar specifically made that allegation of proximate cause. It's specifically pled. And this court has repeatedly said time and again, the Hill case that we cited in our brief and otherwise, that proximate cause is inherently an issue for the jury, except in what the court has called an exceptional case. And by that, what the court means is where you have a situation where the fact pattern is so clear that no reasonable person could possibly disagree or come to a different conclusion that there was no proximate cause. My friends on the other side don't even argue that this is an exceptional case.
Well, but the closest case is Wilmer.
It is.
And Wilmer seems awfully close. And in that case, I don't think we use the exceptional case language necessarily, but we suggested that when you're talking about legal malpractice and a legal outcome based on a attorney's decision or lack thereof, that it's awfully speculative to predict what would have happened. And so that's just not sufficient for proximate cause. How do you distinguish Wilmer?
I'm glad we can call it Wilmer rather than Pietrangelo because I'm going to butcher the
Yeah.
pronunciation. Wilmer is a light years away. It's an entirely different fact pattern, respectfully. If that case, if you recall, the case involved a former client who alleged that the Wilmer firm, by virtue of filing a brief on behalf of another client in the U.S. Supreme Court, asking the Supreme Court to deny the former client's petition for certiorari review, if you remember of the federal don't ask, don't tell statute. His argument and his theory of the case was by virtue of filing that brief on behalf of another client, that the Wilmer firm, had they not done that, the Supreme Court would have granted certiorari review. He would have won, would have gone back to the district court, and the district court would have ended up reinstating him into the military service. That was his injury was I'm not able to serve in the service anymore. There were so many inferential steps in there, right? It involved different, an abundance of, I think we called it compound speculation, right? About what woulda, shoulda, coulda. The theory here is much more straightforward. Mr. Tovar's proximate cause theory doesn't rest on compound speculation because his theory is that his injury, meaning that he's now foreclosed from seeking recovery from the McKesson defendants, who were the defendants in the underlying case, for the lifetime of care that he's going to need. That was a direct and proximate and foreseeable, certainly foreseeable event or consequence of the defendants not asking for those damages at trial.
How do you distinguish the Venable case? That's the settlement case.
It is.
And I think it's leaving out the nuances of differences, it's possible to characterize this case as a Venable case. Your client himself was the cause of not being able to get this money from McKesson because you settled with them. The end.
That's what they argue. Yes,
Yeah.
yes, my friend on the other side.
Why is Venable distinguishable?
So two answers for two reasons. One is if you look at the Venable case, and particularly the case that was cited by my friend accompanying it, it was the Maryland Court of Special Appeals decision. It was Vogel versus Tuitt. Vogel recognizes, and was Judge Hollander had an extensive, as is typical of her writings, an extensive discussion of the law. And she noted the general rule is by far, simply because a lawyer, or excuse me, a client settles an underlying lawsuit does not foreclose a future medical malpractice claim. That's not how it works. Except when, Your Honor, and this is where we get to Venable, except in cases like Vogel and Venable, where the client settled the case knowing that the lawyer had committed the malpractice and knowing the damage that the malpractice had done to his case. Right. So, for example, Venable, at the time Venable brought its malpractice claim, or so, excuse me, at the time the client in Venable settled the case, they'd already fired Venable. They'd already been terminated. They accused Venable of not helping to participate in settlement negotiations, not being involved in the case, and they fired them, brought a counterclaim against Venable for the very claims at issue, and then settled the case. So they knew at the time, and it's almost an estoppel argument. It's like, you know what your lawyer has done, you know the damage that he's caused, and you're aware of it. So that's.
But how did Mr. Tovar not know when he settled the underlying claim that future expenses had not been requested? He might not have known that they should have been or that they could have been, but he certainly knew that they hadn't been.
So, Your Honor, he had said Mr. Tovar specifically addressed this in his affidavit in his in opposition to summary judgment. His position was that during the representation, I did not know that I could claim my future medical care that I had not yet incurred as damages in the underlying matter. I did not object to the defendant's failure to assert a claim for my future TBI, was this traumatic brain injury, my future TBI care, and I did not recognize the defendant's omission of the claim as problematic. That's the distinction, Judge Thompson, from Venable and Vogel in this case. In this case, Mr. Tovar, with drawing all inferences in his favor, and looking at this case, if it were summary judgment, in the light most favorable to him, and Judge Shooter, if it's Rule 12b-6, again, as you asked, all inferences are drawn in his favor, and that's a disputed fact question. That would be something that would be litigated would have to be litigated if the case is remanded, but that's the distinction.
I wanted to, I'm sorry.
Sorry, go ahead.
No, I just a factual point I wanted to ask you about, in the law firm's motion to dismiss or for summary judgment, they said something to the effect of, along with this filing, we're delivering to Mr. Tovar all of our interrogatory answers or discovery responses or something. My question is, did they do that?
They claim that they have turned over the client file. That was in their filings below, and in the oral argument, the representation that was made to the trial court was, we turned over everything on our client file immediately to Mr. Tovar because we wanted to make clear there's no need for discovery. So as to sort of to cut them off.
All right. So to go to your point about you don't know, Mr. Tovar doesn't know what DC bar members they spoke to. They didn't turn over anything.
That's not in the client file.
To.
That's exactly right. That's the problem. And Your Honor, respectfully, I would want to know exactly what they chose to include in that client file. And what they did not, what they chose to exclude. I'm not suggesting wrongdoing. I don't mean to imply, but how did you keep the file? What got kept in it? What didn't? I don't know what that means when someone says I've turned over my client file. Does that mean every scrap of paper? The record doesn't say.
Yeah. Do you have a follow-up?
No.
Oh, so on a slightly different vein, something I've just kind of wondered about, and I didn't see it as pronounced in this, but your client's consent, feelings, desire to move in certain directions play very prominently in this case. Is there any way in which that TBI plays out here in either how your counsel could have done things or how his previous counsel should have treated him or dealt with him? I know that's mostly out of left field.
No, but I have to think about it for a moment. I suppose, Your Honor, I'm going to answer your question. I suppose that takes us right back to the issue of fact. That's part of the issues that would have to be resolved at trial. Well, first through discovery, right? But the record is entirely incomplete, but fair question.
Counsel, can we, if this is all right with my colleagues, turn to the statute of limitations question?
Please.
So there's one date, May 7th, 2019, that seems to be pivotal if both sides adopt it as the triggering date. And I know you've suggested some dates that post-date that, but let's focus on May 7th. Everything seems to turn on whether the last date of that limitations period is May 6th or May 9th. Well, May 6th or May 7th, May 7th is a Saturday, pushes it over to May 9th. That all turns on counting the leap day that's in there. Seems crazy that we're talking about this, but everything turns on leap day. Both sides have different views on what the last day of the limitations period is. No one has told us what the governing law is on whether we count that leap day or not. And that seems to be very important here. So what's your?
So, Your Honor, on this issue, because this came up late in the briefing, we actually filed a motion for leave to file a surreply to address this point. And
All you do in that is calculate the dates again for us, which is helpful, but I don't know what the authority is for whether we count 1,095 days or 1,096 days.
So you see, Your Honor, in the reply brief on the we cited a whole page full string of cases. Every authority I could find from the federal district court, including here in the District of Columbia, that had addressed this issue has said repeatedly, and particularly not only addressing just leap year in general, but leap year in 2020. I found cases that said 2020 is the leap year under the corollary federal rule of civil procedure, which is identical to the DC rule, that the leap year is the leap year day is counted, right? And they say that because, for example, Rule 6 says when the period is stated is in days, or excuse me, let me start over. When the period is stated in days or a longer unit of time, rule subsection B, count every day. Count
Right,
every
but
day.
yeah, but it's not set forth in days here. It's set forth in years.
Correct.
Yeah.
So it's set forth in days or a longer unit of time. So this would be years, right? Years would be the longer unit of time.
Yeah.
I've even found in the Oregon Court of Appeals that they said it definitively when you.
I mean, there are a lot of cases that say when it's set forth in years, you do not count an intervening leap day. So.
Not this one, respectfully, the authorities that we found said that at least.
Okay.
Can I, Your Honor, since you started down this path, can I bring up another point? The trial judge conducted the continuing representation rule analysis under the assumption that the triggering date would have been during the time period of the representation. So she made the finding that May 7th, 2019 was the last day that he could. Respectfully, that was an issue of fact. Mr. Tovar had indicated that, in fact, and then produced evidence showing that August 1st, 2019, under the continuing representation rule, should have been the final day, because that was the day on when the defendant sent him his closeout letter and he got paid. Remember, the way that the engagement letter reads in this case, it says that the defendants would represent Mr. Tovar. Get to my page. Would represent Mr. Tovar in. Would represent him in the litigation or in settlement of his claim. Excuse me, I lost my place. They would represent him in the litigation or settlement of his claim. They were still holding $18,000 of his settlement money and did not return it to him until August 1st because they were still negotiating and working out medical liens that had to be resolved. Now, I know our colleagues, my friend on the other side has said that was just a ministerial task. That doesn't count. Again, I think that that's a question of fact. The cases that they cite where the continuing representation rule stops, those involved different fact patterns, respectfully. They involve where the law firm was hired to do task A and the work bled over into task B. The continuing representation rule says that it's when the work on the particular matter terminates, right? So in that instance, where you have law firm with doing two different matters, you don't get to tack on the second matter to the first and call it continuing representation. That's not what happened here. This was, again, their retainer agreement was that they would represent Mr. Tovar in litigation or settlement of his claim. This was directly related to the settlement of his claim. If I hired a lawyer and he was holding $18,000 of my money and I was waiting on him to finish his work to send it to me, I would certainly think that he's still representing me, especially if he's resolving medical lien. Can I make one other point, Your Honor? It occurred to me some of the best ideas you come up with are out in the hallway before oral argument, but it occurred to
Are they
me.
the best preserved ideas, though?
Well, the good thing is I'm not the appellant, so I can raise new issues on appeal, right? Um, there may be no need for the continuing representation rule at all. Depending on how the discovery comes out and how the facts are resolved. Remember, the continuing representation rule is an exception to the discovery rule. So, for example, the reason it's there is because let's say that the client finds out about the malpractice during the time of the lawyers, that the lawyer's still representing the client. This court said in RDH Communications, we don't want to put the client to the unenviable choice of having to either one, fire the lawyer and bring a malpractice claim, or continue to work with the lawyer and run the risk that the statute of limitations will run. Right? At oral argument below, I remember that I read this last night. The trial judge had asked Mr. Tovar's counsel, well, when did Mr. Tovar know he had a claim? Right? That's the question you would, when did he know? And his counsel said, again, of course, the counsel's colloquy with the court is not evidence, but I just raised this for the possibility. Counsel said, it's an issue of fact, but I think it would at least be after sometime in 2020. If that were true, if that's true, that's when that's when Mr. Tovar knew or should have known, and that's when the accrual date started, then there's no need to worry about the termination date of when, right? Because it's
Well,
after.
that argument seems to prove too much. I mean, Mr. Tovar could have realized and could have been reading a law book in 2028 and found out that his attorney could have asked for it. But you're not suggesting that that's when the statute of
No. My point, Your Honor, is I'm just saying it's, again, factually incomplete record. It's possible depending on, I'm not saying he would have, did, or about making any representations about when he knew. I'm just saying, depending on how if the evidence comes out and how what the discovery is and what findings are made, because again, the court never made a finding about the discovery. She didn't say when he knew or should have known. She just made a determination about the COVID tolling orders, which I don't think this court needs to get into, and then the continuing representation. But I'm just saying that that's another possibility that, again, why her ruling was correct, that that's an open question. The ruling was correct, not dismissing on statute of limitation grounds.
All right, if there's no further questions from my colleagues, thank you, counsel. Your 4
Thank you.
minutes are reserved.
Thank you, Your Honor.
Good morning, Your Honors.
Morning.
Morning.
May it please the court, my name is Paul Maloney. I represent the Regan Law Firm and two of its attorneys, Patrick Regan and Paul Cornoni. Your Honors, in my years of practice, I've represented a lot of professionals, and I've represented a lot of professionals in legal malpractice cases. I've never had one quite like this, where the result that was achieved at a trial was far greater than what the trial counsel expected, and frankly, what Judge Schuker thought would be the result based on two mediations that she had. And Your Honors, you know well from the record that the result here was a jury verdict in the amount of $3,797,573, almost $3.8 million. And ultimately on appeal, it settled for that exact number. Now, Mr. Tovar was heavily involved in this case every step of the way. He was involved on the medical side of the case. He went to approximately 50 different doctors for his treatment. He directed his own treatment. If he didn't like a doctor, he went to another one. He directed his counsel. He fired his first counsel, Mr. Strawn, and he went to what is probably the finest personal injury law firm in Washington, D.C., the Regan firm. And Paul Cornoni did an outstanding job on his behalf, both pre-trial and during trial. Now, Your Honors, and Judge Thompson, you made a great inquiry of my opposing counsel here. We got this case and we looked at it and we said, how can this possibly be considered malpractice? We have a complete record of everything that took place. We have a trial, we have depositions, we have the appeal records. We're going to turn over everything in this case to the other side, and we think there are no factual issues here. We're going to file a motion to dismiss or motion for summary judgment. We turned over everything, Your Honor. They have the complete file from the plaintiff's law firm that they had at the time that the motion to dismiss and or motion for summary judgment was pending. And we filed both a motion to dismiss and a motion for summary judgment to give the court the option to grant one or both. And Judge Scott did exactly that. And Judge Scott got it right in this case.
But so counsel, I mean, I get everything you're saying, but doesn't a plaintiff in Mr. Tovar's situation have the right to say, yeah, I got a huge verdict. And yes, I was very involved in my representation and they consulted me on all kinds of things, but they didn't consult me on X. And even though I got a huge verdict, X would have gotten me an even bigger verdict. I mean, how is that not a cognizable claim?
For two reasons, Your Honor, and probably many more, but two that come to immediate mind. Mr. Tovar was involved in the pretrial proceedings. He went through the two mediations with Judge Schuker. He went through the pretrial conference. He was aware of what claims were and were not being made. He rejected a settlement offer immediately before trial of $750,000. The last that we could see in all the records that we looked at was he was holding out for $4 million. So he got what he wanted. This went to trial because he insisted upon it and he got what he wanted. It was 3.8 million, not 4 million, but very close to it. He gave up the interest on appeal. So he got what he wanted. And there's a second reason, and I've now lost my train of thought, but I know there's a second reason, Your Honor. He would not be entitled to discovery in this case on any of these issues because he has and his counsel had the entire file that was turned over.
I mean, that's the case file. I also don't know what was in it, but to the extent he is saying they never asked me, they forgot to ask for X, right? I don't know if the case file sheds any light on whether your clients forgot to ask for X or thought about asking for X and told him that they were not going to ask for X. Of course, X being future financial care.
Right.
So where is that? Was that in the case file?
It is, Your Honor, and we addressed this in the reply to the motion for summary judgment, to the motion to dismiss or for summary judgment. It was clear that there was going to be no past medicals that were asked for, and that is in the record, very clear. The past medicals were about 350,000 or so, and there was discussion with the client, and there were emails to that effect. As far as future medicals, that had been discussed at mediation, it had been discussed at the pretrial conference, but there's also emails that took place and it was about a week to 10 days immediately before trial, where Mr. Tovar raised the question about future medicals. Is this doctor going to testify to that? And then there was a response, oh yeah, I got my answer to that. So that is in the, emails that are attached to the reply to the motion to dismiss or for summary judgment. So it was addressed. Now,
Yeah,
Your
the
Honor.
question though was, why didn't the complaint here state a cognizable claim? And to an extent, there's a bit of tension between our pleading rules and our legal malpractice case law, which talks about the case within the case and the likelihood of success in that case if it had been brought or if a claim had been brought. And the pleading rules, the 12B6 rules, which just ask us to consider whether there were enough factual assertions in the complaint such that if taken as true, they would support a plausible inference that the plaintiff would have fared better if the lawyers had done something different. I really am getting to a question, I promise you. So in this case, the complaint says something like in one of the paragraphs, at least one healthcare provider was prepared to testify that I would have needed a lifetime of medical care for my traumatic brain injury. Now, taking that as true, you might conclude, well, that states a claim. And you could at least see that a jury, even a jury that awarded $3.8 million for loss of earnings, and even if it heard the kind of evidence that Mr. Cornoni included in his affidavit about the plaintiff's doctor shopping and other things, a jury might have said, well, you know, what one provider saying that he needed care, that might have been enough to bump the jury verdict up to $4 million, you know, $200,000 for a lifetime of care. So I'm having a hard time understanding why that doesn't state a claim under 12b-6. Now, as I said, when you get to the question of, is there too much speculation for this to survive on summary judgment as a legal malpractice claim, maybe that's another question, but could you address my 12b-6 point here? Why taking the allegations of the complaint as true? Why is that not enough to state a claim for legal
Your Honor,
malpractice?
I'll try to address it. And I agree with Your Honor that there is tension between the 12b-6 rules and the broad consideration that's given to the allegations in a complaint. And it's actually specifically why we filed the motion the way that we did here. And we wanted to bring everything to the court and to say there is no basis here. There's no basis either if you look just at the pleading itself. When you consider items that are outside of the complaint, but either referenced in the complaint or matter of public record, and there were plenty of them. We had the trial transcripts. We had the pleadings in the underlying case. We have the docket entries here. Docket entries show that Mr. Tovar was present in court on 4 of the days. And he says that he wasn't there at all. He was there. And he saw what took place in the court. So yeah, there's a tension between the 12b-6 rules and something that's well pled, and should it be allowed to go forward? In this case, it should not be. And the judge got it right. When considering the matters that we put before the court that were properly considered for the 12b-6 motion, Judge Scott ruled that there was a knowing and voluntary settlement. This was point 1 that she had. And I believe it's the point that came up in your questioning of opposing counsel. Why isn't that the end? This is a known settlement on appeal. Mr. Tovar knew that all of his future medicals are extinguished at this point.
So are you defending the trial? The trial court seemed to treat the settlement in a slightly different way by maybe assuming that your clients were released from future liability in that settlement. You're not defending that.
I didn't read the order that way, Your Honor. I think what Judge Scott says in the order is that Mr. Tovar is aware of the verdict that came down. He is the one that decides this is the settlement I want, and he agrees to it. And in that settlement agreement, he says, I've had advice of counsel. It's a complete knowing waiver to any future claims, any future damages that he has. And yes, it is between him and McKesson, the defendant below, but it releases everything. He can't have it both ways. He can't say on the one hand, yes, I have no more future claims against McKesson, but on the other hand, I'm going to sue my attorney down the road 3 years later for future claims. He can't have it both ways. And I think that's what Judge Scott was saying.
And what if, and I know this is, I'm not saying this is what happened here, but what if his trial counsel had asked for the nominal damages from the jury, $1, and Mr. Tovar's not an attorney. He doesn't know that you can ask for more than that. And then he settles for $1. He finds out later, could have gotten compensatory damages. I could have gotten punitive damages. I could have gotten all kinds of things. I didn't know that. And are you saying he has no recourse against his trial counsel?
I think that's a very different case than we have here. Under that hypothetical, he may have recourse, but I think that's not what we have here. Mr. Tovar was engaged every step of the way. He knew what was going on. He knew what was being asked for at trial. He was there at opening statement. He was there at closing argument. He testified on the stand. He was there every day in court. The docket shows that he was present in court on 4 days. If we ever did get into discovery in this case, we'd show that he was present more than that. But the docket shows that he was present for 4 of the 6 days of trial.
So do you think his legal understanding of whether, and I'm not saying he was necessarily entitled to future earnings, but are you saying his legal understanding of whether he could or could not have asked for that is not really relevant to the only relevant question is whether he knew that it wasn't being asked for?
If I understand the court's question, I think what we're looking at here is judgmental immunity, and we've talked about that. This is the judgment of the attorney on how this is going to be handled. And here, the decision was made by Mr. Cornoni not to present any future medicals, just as he made the judgment not to present any past medicals. So, and whether or not Mr. Tovar should have been told that or not, we believe that he was. That arguably is a fact question. He says he was not.
Counsel, what chance did Mr. Tovar have to really challenge that? Usually when we're looking at what an attorney did and whether it was a reasonable decision or not, you know, we've had a hearing and there was a hearing in this case and there's a chance to challenge it. But part of what's before us now is that Mr. Tovar allegedly wanted some discovery to undermine that prong one argument your opposing counsel's making as compared to moving straight to prong two. How do you respond?
Your Honor, my response is that Mr. Cornoni did a phenomenal job at trial. It was prong one. Was there an alleged error of professional judgment which is prong one of the Biomet case? There was no error of professional judgment here. This was the strategy going into the case. The opening statement didn't ask for any future medicals. The closing argument didn't ask for any future medicals, and there were none that were asked for with any of the witnesses during trial. Mr. Tovar sat there the entire time. Could he have said something to his attorney during the trial? Yes. Did he? No. So
counsel, the trial court said that it was not deciding this under summary judgment, but that it was deciding it under 12b-6. You obviously moved in the alternative. I mean, what's your position on what the trial court actually did here?
The trial court did decide this on the 12b-6 on 2 grounds. One was on she found that there was the settlement, the knowing and voluntary settlement. The second ground was, and we touched upon this earlier in the argument on the speculation. So those were the 2 bases for the 12b-6. She then said in the alternative, although
speculation on proximate cause.
Well, it was speculation, proximate cause. I think it was kind of blended in there.
I didn't see that in the ruling, but okay.
I thought that was the heading of the ruling was speculation, but I may be wrong. But then on the summary judgment portion of this, what she said was that she didn't need to get to the summary judgment issue, but if she did, she would rule in favor of the defendants in that case. And again, she based this on the fact that there is no discovery needed. The facts are not in dispute here. You have the complete record that's before the court. All the transcripts were there. And I would also point out to your honors that while Mr. Tovar submitted an affidavit to say that we should get discovery in the case or he should get discovery, there was never a specific request to take the deposition of Mr. Regan or Mr. Cornoni before the decision was ever made by the judge. They could have asked for the depositions. We would have given it to them, but they didn't do that. And they never came forward. And this is what we expected in the opposition to the motion to dismiss or for summary judgment. We thought that there would be an expert that would come in and say, aha, I've now looked at the file and there is a basis for legal malpractice here from some practicing attorney in this town.
But
And
the
that didn't
deadline
happen.
for naming your experts hadn't passed.
It hadn't passed.
What bearing does that have?
It hadn't passed, Your Honor. It has no bearing because when a motion for summary judgment is filed and we are saying that, and we did say there's no expert that's been provided here, they had to come forward. We're saying there's no malpractice that's been committed. They had to come forward at that point in opposing the summary judgment with an expert. They didn't have a standard of care expert. They didn't have an expert to say a vocational expert or some type of expert to say what the future medical care was going to be needed.
Did
for
they
this individual.
propound any discovery? You say they didn't ask to take the depositions. Did they?
They propounded interrogatories and requests for production of documents. We answered the interrogatories, and they're in the record, and we responded to the request for production of documents. We opened up the file, gave them everything.
Did you answer a question about what DC bar member or members Mr. Carnoni or the lawyers consulted?
I don't recall, Your Honor, without going
Mr.
back.
Tovar's affidavit, or maybe it's his filing, says something to the effect of, well, I don't know who they consulted. I don't know what that person told them. I don't know what they told the person by way of representation of the facts to seek advice. I don't know who else they consulted. I don't know whether the DC bar members they consulted gave consistent advice, whether there were, some who said, oh, yes, you must present evidence of ongoing need for medical care, and others who said not. And those things bear on whether the decision made was a reasonable one. Are you saying that discovery was irrelevant?
Your Honor, the answer is, I think it was irrelevant. And main reason for that, or at least part of the reasons for that, is, as I made reference to, and I'm going to be careful about how I say this. There were two mediations that took place in this case with Judge Schuker. Mediations are confidential, but there was an evaluation that was given during the course of these mediations. That's part of what Mr. Carnoni relied upon in evaluating the case. Judge Schuker evaluated the case. All of this was made available to Mr. Tovar. He was present during this, and that led to ultimately the maximum settlement that was offered before trial of $750,000. And it's in the record that Mr. Carnoni recommended that settlement to his client, Mr. Tovar. And he said, the risk is on you. If you don't accept this and we go to trial, the risk is on you. Reason being is because Mr. Carnoni wasn't convinced that the judgment a finding would be more than $750,000. So, Your Honor, I think it is irrelevant as far as who he talked to. Did he talk to his law partners? Did he talk to somebody at a bar meeting? Hey, I got this trial coming up, and what do you think? I do think it's irrelevant, Your Honor. It was a reasonable judgment that he made, and under the judgmental immunity rule, it was a right way to handle this case. And as Mr. Tovar himself pointed out after the trial, you have just gotten the highest verdict in an automobile accident case in this jurisdiction in history. He was ecstatic with the
Well,
verdict.
what's your response to this point? Maybe the discovery was not relevant, maybe not, but I think it's the case, you can correct me if I'm wrong, that the trial court didn't consider that one way or the other. In other words, maybe the trial court was entitled to exercise some discretion in looking at this as to whether the discovery would impact anything, but she didn't talk about discovery or consider it. So maybe we should send this back for her to reconsider, or at least to rule on whether discovery would have been proper. What's your reaction to that?
My reaction to that is, number one, it was in the record, and it's not in the order, but she did consider it. It was not reflected in the order, but I think it was addressed at the hearing. I'd have to double check on that. But if hypothetically this were remanded to Judge Scott, what we would ask for at that point is to make the same arguments I'm making here, and to say, Judge, everything is before the court. It's been given to the opposing side. There are no issues subject to discovery in this case. There's nothing that needs to be done further. Grant summary judgment at this time, as you said in the order you would do, but you didn't have to get to it. That's what we would ask for. And then I think we're right back here again. So I think we obviate that by this court saying either, number one, the motion to dismiss is upheld, should be upheld, or number two, Judge Scott should have should have entered summary judgment at the time that she signed the order.
All right, if there's no further questions on these points, do you have a stance on the statute of limitations question?
We'll submit on that, Your Honor. It's, do you have questions on it? Or,
I mean, I just have one, like,
Yes.
if we are, that regularly, if you practice in Superior Court, you see there are things that instead of saying months, like a track 2 scheduling order.
Right.
We say 90 days for this instead of 3 months or something like that. Do you see a reason why it wouldn't be reasonable to take a calendar year for someone observing it, whether an attorney or a layperson, and just say it's a calendar year, however that year falls?
we did as much research as we could on this, Your Honor, and I don't know, I frankly don't know what the answer is, but it's, Judge Scott said it's, what was it, 1,095 days, I think was the number. And what we got hung up on is the COVID orders that were issued by the trial court. And is there a tolling period? It would have to fall within the tolling period from those orders that came out. And there's a conflict with the trial court judges on how that's interpreted. And that really, I thought, was the key point that probably needs some clarification. And Judge Scott says it's what is it, 1,095 days, I think is what she said in her order. And it's, we couldn't find anything one way or the other definitively to say that you take 3 years and you add 1 to it in a leap year. And I don't know how to answer that.
Okay, so one final question there then. If we're focused on the COVID orders, do you see just logically why someone would, if they didn't have access, if someone didn't have access during COVID, if their case statute of limitations ended 1 day after the order ended,
Right.
why they would have had more meaningful access? I know this isn't the case where it cut off 1 day
right.
after, but.
And that's a tough question, Your Honor. I think it would have to probably come down to asking for leave of court to have an extension of some type. And if it was that close, but I think a strict reading of the COVID orders would say that the tolling period applies to those that end during this period of time. And that's what we pointed out. I would also say just one last point on the continuous representation rule. It certainly applies, but the only thing that was done by the law firm was administrative and ministerial after the settlement took place. The settlement took place it was April 25 of 2019. The dismissal in the court didn't take place until May 7th, 2019. And that's why Judge Scott looked at the May 7th date as the final, as the act for looking at tolling. But I really think that it was the April 25th, 2019, when Mr. Tovar entered into a knowing and voluntary settlement. I think that's the date that should apply. And that makes our argument stronger, I think, on the statute of limitations.
All right, there's no further questions. Thank you, Mr. Maloney.
Thank you, Your Honor.
All right, Mr. Ogletree.
A few quick points. There's a lot of people in the trial court below, even here, making determinations and definitive statements about what Mr. Tovar knew, about what Mr. Carnoni did. And I'm going to just harken back to what this court said in Biomed. Simply because a lawyer takes the position that he made a strategic choice and the decision was covered by the judgmental immunity doctrine doesn't make it so. It's his burden to prove that, and there are issues of fact of whether that was actually a strategic choice or was it neglect and malpractice. And even if it was a strategic choice, was that reasonable under the circumstances? I want on that issue, Judge Sugar, earlier, my colleague, you asked him whether there was anything in the record indicating that the law firm had told Mr. Tovar that he had a claim for future medical damages, or that he knew. My friend referred to a series of emails that he referenced. These emails were shortly before trial. They were attached as a reply brief for the first time in their motion to dismiss, motion for below. And the emails, which there was two of them. The first came from Tina Edwards, She was Mr. Cornone's legal assistant. And it says email from Tina to Paul, Mr. Cornone, which was hearsay because it was objected to on that grounds, not admissible for summary judgment. He said, Roger called and would like to ask you whether we should request a report from his treating physician regarding future care costs. He also wanted to ask about having Dr. Ross, one of his other doctors, rebut Dr. Shretland's report. And later, there's an email from Mr. Tovar back to Tina saying, later that same day, on June 5th, I just spoke with Paul. He's at lunch. Questions addressed. See you on Friday, the 15th, I hope. So the problem is that there's no indication of what was discussed on this June 5th phone call. There's no record evidence of what it said. Oddly enough, Mr. Cornone submitted an affidavit in support of the judgmental immunity defense, but he never says what was discussed on that phone call. And the trial court acknowledged as well, and during the oral argument, she said, it's not clear to me that these emails actually say that. So again, disputed fact issue. All of the other evidence that was submitted by the defendants in an effort to demonstrate what Mr. Tovar knew, what Mr. Cornone or Mr. Regan did or hadn't told him. Again, none of it definitively establishes any of those facts, none. On the issue of whether Mr. Tovar knew, my colleague says he was in court every day. I want to read you what Mr. Cornone argued to the jury at closing argument. He said, one of the reasons why we didn't have Mr. Tovar in here during the trial is you look at him and you think he's fine, but it's obviously not good for him to hear what everyone is saying about him. Mr. Tovar was there for the opening arguments, for closing, and for his testimony, but they had him sit out in the hallway during most of the trial when everyone else was testifying for the reason that Mr. Cornone just said. Now, I understand this leads to my bigger, broader point in response to most of my friends' arguments. Mr. Tovar says he didn't know he had the option, a legal option of bringing a claim for future medical care. So whether even if he had sat through the whole trial and and saw that there was no future claim for medical care made, if you don't know you can't bring the claim, then the fact that it's not brought isn't going to trigger something in your head that, hey, maybe there's a problem here. That's the position that he's taking. So I just wanted that responds to most of what my friend said. A couple of other issues, and I will realize my time is up. The mediation evaluation, Mr. Tovar specifically addressed that in his affidavit. He said, the judge running the mediation never told me anything about whether I should or shouldn't assert a claim for future care damages. And we've addressed the other issues in our reply brief in the footnotes. We've addressed all of these items. Speculation. Whether Mr. Tovar would have succeeded in recovering future medical care costs at trial below, or how much more the jury would or would not have awarded him. This is exactly the question that the burden that Mr. Bohar would bear at trial under the case within the case doctrine. That is exactly this is precisely where it applies. The same is true of any other case where a lawyer has allegedly committed malpractice and failing to protect the client's claims or in a similar situation. This is how it's done. This is not an exceptional case. Not even being argued, it's an exceptional case where the proximate cause issue would be taken away from the jury. I had a lot of notes here, but it's a lot of scribbles. Does the panel have anything else for me? I realize my time has expired. I want to be respectful.
We don't, counsel. Thank you very much for your time, and the case is submitted.
Thank you.
Thank you.
All rise.